Hello, my dear students. Today we'll talk about the procedure for certification of standing orders. As you all are aware that an establishment where 100 or more than 100 employees are working in the establishment, then it is the duty of the employer to go for the standing orders. Today we'll talk about the procedure for certification of standing orders given under section 5 of Industrial Employment Standing Orders Act 1946. See, when the draft of standing orders are submitted for certification, the certifying officers shall send a copy of the draft to the trade union, if there is any trade union, if there is any existence of the trade union, or in its absence, to the workman concerned. If trade union is not there, then these this copy would be sent to the workman to file the objections. If any objection, if the trade union is there, then trade union will may object, or if the workman is there, then workman may object. In respect of the draft of standing orders within 15 days of the receipt of that notice. So, my dear students, whenever a draft would be submitted for the certification of these standing orders, the certifying officer will send a copy of that draft to the trade union, because see, ultimately these rules regulations given under those standing orders for the certifications are for the workman, or these are for the trade unions of those workmen. So if there is any trade union, then trade union, and if there is no trade union, then the workmen, they may file the objections. If there is any objection regarding the standing orders submitted for the certifications, and this objection has to be filed within 15 days of the receipt of that notice. So whenever the workmen or the trade unions, they are receiving the copy of these standing orders for the of the standing orders, then within the prescribed time frame of 15 days, they may go for the objections. And further required to provide hearing opportunity also. These certifying officers, they must provide a hearing opportunity to the trade union if there the trade union exists there, or the workmen concerned, as the case may be. So if there is a trade union, then the trade union may raise the points or whatever objections they are having regarding those standing orders, and if there is no trade union, then the concerned workman, so whatever the case may be, accordingly they can just go for the objections related to those standing orders. Certifying officer, after hearing, make necessary modifications, I beg your pardon. Certifying officers, after hearing, will make necessary modifications in the draft of standing orders. So if the trade union or the workmen, they are going for some sort of modifications, they want, or they have raised some point, or they have filed some objections for some regarding some standing orders, then certifying officer will hear and will make necessary modifications accordingly in the draft of a standing order submitted for the certification, and if required, and certify the same shall within 7 days thereafter, and send copies of the standing orders authenticated by him, means by the certifying officer, to the employer and to the trade union as well, or the prescribed representative of the workmen. So whenever these trade unions or these workmen, they are filing their objections, then the certifying officer will hear the matter, and accordingly, will incorporate those changes, those modifications into the draft of standing orders if it is required, if he is convinced that their objection is valid, and then will certify the same, and within 7 days thereafter will send the copies of the standing orders, which the certifying officer will authenticate and will send to the employer, will send to the trade union and the prescribed representatives of the work. And one more thing I would like to highlight here, that on receipt of the draft under section 3, the certifying officer shall forward a copy thereof to the trade union, workman, or where is there is no such trade union or there is no workman, then together with a notice in prescribed form requiring the objections, if any, which the workman may desire to make the draft standing orders to be submitted to him within 15 days from the receipt of that notice that we have already discussed. And after giving the employer and the trade union, as I told you, the such other representative or the workman, as the case may be prescribed, an opportunity of being heard, the certifying officer shall decide whether or no any modification of or addition to the draft submitted by the employer is necessary to render the draft of standing orders certifiable under this act, and shall make an order in writing accordingly. Certifying officer will just take care of this thing. And the certifying officer shall thereupon certify the draft standing orders after making those modifications, as I have told you, and which his order under subsection 2 he may require and shall within 7 days thereafter send the copies of those certifying standing orders authenticated in the prescribed manner, and of his order under subsection 2 to the employer and to the trade union and other prescribed representatives of the trade union, as I told you. See, this act, this Industrial Employment Standing Orders Act, it applies to every industrial establishment where in 50 or more workmen are employed or were employed on day of the preceding 12 months. So, and employers of industrial establishment engaging 15 or more workmen are required to obtain a certifying standing orders for their establishment. And for the purpose of this act, all the deputy labor commissioners of the field and the joint labor commissioners headquarters have been declared as certifying officers under the provision of this act. The employer of the industrial establishment to which this act applies has to submit, the 5 copies of the draft of standing order proposed by him for adoption to his industrial establishment to the certifying officer of the area for certification. So my dear students, I repeat that employer of industrial establishment to which this act applies has to submit 5 copies of draft of that standing orders. So there would be 5 copies of that draft, and which would be proposed by him for adoption to his industrial establishment, to certifying officer of the area for certification. And provision shall be made in such draft for every matter set out in this schedule, which may be applicable to the industrial establishment, and where model standing orders have been prescribed shall be, so far as is practicable, in conformity with such models. So whenever you are just making the draft of standing orders as an employer, you have to check that if the model is whether the you are complying with the model standing orders. If it is prescribed there, then accordingly you have to just check it, the whether your standing orders are in conformity with that such model. And the draft of those standing orders submitted under this section shall be accompanied by a statement giving the following particulars. So we will just discuss certain particulars. Whenever you are submitting this draft of standing order, that has to be submitted with those following particulars, or these items would be included into that. The total number of the workmen or the employed, and the number of the permanent workmen, how many permanent workmen you are having in your industrial establishment, the number of temporary workmen you are having in your industrial establishment, number of casual workmen you are having in your industrial establishment, number of badlis or the substitutes you are having in your establishments, number of probationers, number of apprentice employees you are having in your establishment, name of the trade union, if there is an existence of the trade union, that the name of the trade union, and to which the workmen belong, that you have to mention. And if any remark you feel that there has to be some remarks, then you can also incorporate that into the draft of your standing orders. And on receipt of the draft of a standing order, certifying officer will definitely or shall forward a copy thereof to the trade union together with a notice in form second would be followed there. And where there is a trade union functioning in the industry, where there is no such trade union, then certifying officer shall hold election of 3 representatives by the workmen from among themselves, or authorize any officer in working to hold such election, and thereupon shall forward a copy of such notice in form second. And certifying officer, after hearing, make necessary modifications as we have already discussed in that draft. Then within 7 days, we'll send the copies of the standing orders authenticated by him to the employer and to the trade union or the prescribed representatives of the workman. And any employer or workman or trade union or other prescribed representative of the workman, if aggrieved by the order of the certifying officer, may within 30 days, uh, you just remember this number, within 30 days from the date on which the copies of certified standing orders are sent, shall submit a memorandum of appeal setting out the grounds of appeal in form fourth. In quadruplicate appeal to the appellate authority, and the appellate authority shall, after giving the appellant an opportunity of being heard, shall pass final order on the appeal petition, and his decisions shall be final. So if there is any agreed person, then with those standing orders, maybe the employer, workman, trade union, right, or their representatives, they can go in such a manner for the appeal. And the district and the session judges, of the state have been declared as the appellate authority under this act, the Industrial Employment Standing Orders Act, within their respective jurisdictions. So the district and session judges will be the appellate authority under this act within their respective jurisdictions. So thank you so much, my dear student. This is all about for today's topic, that is the procedure for certification of standing orders. So today we have just gone through that how we can go for the certification of the standing orders, in how many copies we need to submit for the certification, and to whom we will submit these draft of the standing orders, and how the certification officer will act once you submit the draft of the standing orders. And if some party is agreed with those standing orders, then in what way they can go for the appeal within the prescribed time frame. And we have also discussed that who would be the appellate authorities, for the purpose of this certification of the standing orders. So all those points, and we have also discussed about the total number of or we have discussed the items which we should incorporate while we are framing the standing orders. So in that way, we have just covered these points related to the procedure of certification of the standing order. So I believe this lecture will help you, and thank you so much, my dear friends. And in next lecture, we will take up some other topic related to the standing orders. Thank you so much and have a nice day. Thank you.